Hello, my name is James Walker, and this is my presentation on the Fourth Amendment and the Exclusionary Rule. And this is for my project for LSTD 3223, the American Judicial Process. Some of the things I'm going to be going over in this presentation is my introduction and thesis statement, also types of law, history, and explanation of the Fourth Amendment, the exclusionary rule's purpose, the actual effects of the exclusionary rule, and the flaws associated with it. And then I'm going to end with a re examination and a statement of the need for transformation of the exclusionary rule. So I'm going to begin with my introduction. Um, the Fourth Amendment and related laws on search and seizure form the foundation of policing. However, despite the foundational nature of these laws, they're often the laws that are most violated by law enforcement and subsequently provide the basis for most of the litigation against police. Uh, the nuances of changing search and seizure laws take years to fully understand, and that's despite extensive and specific training on the subject. Um, and despite the exclusionary rule and its ramifications for Fourth Amendment violations, the Fourth Amendment is still violated far too often and is heavily contested and frequently litigated in court, prompting the need for the exclusionary rule to be re examined and transformed. So now we're going to go in just very briefly into types of laws. It's important to know where the law comes from and what power these laws have in society. The very first type of law and most basic and foundational is constitutional law. These laws come from the Constitution of the United States of America. Um, there aren't any laws that can oppose what the Constitution says. Uh, Laws can be uh, more restrictive in a sense, or play off of the Constitution, but they can't directly oppose or violate rights given in the Constitution. Included in the Constitution is the Bill of Rights. Um, of course, that's the first 10 amendments to the Constitution, and there are 26 total amendments to the Constitution. And a lot of these uh, rules or rights provided in the Bill of Rights are very fundamental to law enforcement and how law enforcement is able to interact with the public, what they can do, what they can't do. This includes the Fourth Amendment, of course, which is rights to related to search, seizures, warrants, and then the Fifth Amendment, which is the right against self-incrimination, often referred to as the Miranda Amendment. The other kinds of laws that we also see is statutory law. That's codified law in such as your penal codes, your health and safety codes, vehicle codes, things of that nature. Whereas the Constitution is the same throughout the country. Statutory law varies from state to state. You may be able to get away with something in some states and not get away with it in other states. Gun laws are different state to state, for example. Another type of law is case law, and we often refer to case law as precedent, where cases are decided, and the decision in that case basically sets the tone for other similar cases and sets the law for um, cases in the future where they don't really relate to specific codified law, either codified statutory law or constitutional law. Now we're going to go into the Fourth Amendment. I'm going to give you a brief history and an overview of the Fourth Amendment. Basically, the Fourth Amendment provides fundamental rights to American citizens and dictates the rules by which law enforcement must abide in their interactions with the public. The Fourth Amendment, of course, was ratified as part of the Bill of Rights in 1791 and provided additional information to and amended the Constitution, which was written in 1787. I'm going to go ahead and read the Fourth Amendment for you here. The right of people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. And of course, I quoted that from the Neubauer text, so I cited that there. The Fourth Amendment is very important for law enforcement because it's basically our rules, what we can do, what we can't do. It tells you how far or what you need in order to search things. Very clearly sets up warrant requirements and just plain and simply, it's the rules by which we have to play by. But it's also important to citizens because it gives citizens rights to privacy, rights to be able to expect to be secure in their homes and their effects and not have them searched or seized unreasonably without a probable cause. So some of the things that are allowed by the Fourth Amendment, and some of the things that it governs, of course, are searches and seizures of persons. That includes, your basic consensual encounters, your detentions, arrests, includes vehicle stops, vehicle searches, and then searches of premises or residence. Now, with all of these different ways of being searched or seized, it's important to know the difference between reasonable suspicion and probable cause. Each of those provide different layers of a burden of proof that have to be met for certain conditions, whether it's a search or an arrest or detention. And so reasonable suspicion is the belief that criminal activity may be afoot. The person you're about to detain is connected with that possible criminal activity. And then there's kind of an addendum to that both the quality and quantity of the information you need is considerably less than the probable cause you need to arrest or search. And then for probable cause, that exists when the totality of the circumstances would lead a person of ordinary care and prudence to entertain an honest and strong suspicion that the person to be arrested is guilty of a crime. Of course, your training and experience are relevant to a determination of probable cause. What that means is that an expert narcotics officer who's been working a beat for 10 years and knows the street corners, knows how drugs are packaged, how drugs look, what the couriers look like, what sales activity looks like. He's going to be able to develop a lot more probable cause based on his knowledge than a rookie who just goes out there and sees that and thinks something may be going on, but he doesn't have that training experience and base of knowledge to develop a full probable cause without more facts. And it's interesting to note that items items either viewed in plain view or smelled um, from a place that an officer is allowed to be can also contribute to probable cause. For instance, if you are on a legal traffic stop and you walk up to the car and driver rolls down the window, you smell alcohol or you smell marijuana or you smell something or you see a gun in the back seat. Um, all of those things can lead you to develop probable cause to search that vehicle. The smell is the interesting one. Back when marijuana was a little bit more illegal than it is now, um, that was one of the ways we could look into a car was if we smelled marijuana in the vehicle or coming from the driver's breath. We could use that to develop our probable cause to get in that vehicle and search it. Go into the exclusionary rule now. Um, like we said, the Fourth Amendment, was ratified along with the rest of the Bill of Rights, but it really didn't have much teeth to it right away, and so there would be violations of the Fourth Amendment that would occur, but there would be no penalty. Um, People's rights would get violated, and nothing would happen. And it wasn't until Weeks versus United States in 1914 where law enforcement illegally entered a home, obtained some evidence, used it against Weeks, and he was found guilty of involvement in a lottery ticket scheme. Um, well, the court saw that this was obvious. His Fourth Amendment rights were obviously violated, and said this isn't right. We need to do something about that, and they developed an exclusionary rule, which is based on Old English common law, and basically says that in order to uh, deter police misconduct and deter them from violating the Fourth Amendment, they're going to exclude or take away any evidence obtained from that illegal search. So obviously, if I did an illegal search of a car, anything I found in that car would be inadmissible in court. Interesting to note, this only applied to federal cases back in 1914, and then for quite a while after that, um, until there was the Wolf versus Colorado case. Um, Wolf had his rights violated, and um, the court held that because it was the exclusionary rule only applied federally, that because it was a state case, that they didn't have to abide by those rules. Well, it wasn't until Mapp versus Ohio in 1961 that, of course, the police did an illegal search again. Interestingly, Mapp, the defendant in this case, actually told the police to come back with a warrant. They showed Mapp a piece of paper that was not a warrant, but they said it was. Arrested Mapp, and then Mapp was found guilty, and then took the case to the Supreme Court, who saw that it's not right for people's Fourth Amendment rights to keep getting trampled on with no penalties. So they applied the exclusionary rule to all the states, and this was quite heavily contested and made a lot of people angry at the time, because in essence it was going to be releasing criminals who would otherwise be guilty with the evidence that was found, but because the exclusionary rule would be excluding this evidence, we wouldn't be able to get them convicted. So they were just getting released out back into society, basically. And so that was one of the flaws that was that the exclusionary rule had, was that it was releasing people back into public on minor, not misconduct, but minor errors, procedural errors, technical errors, things of that nature. And so in U.S. v. Williams and then also U.S. v. Leon, both those cases applied a good faith exception and noted that, since the exclusionary rule was initially developed to deter police misconduct, if there was a case that wasn't involving police misconduct but instead involved technical errors or minor procedural errors, that a rule to deter misconduct didn't really apply. And so the good faith exception was applied in those cases. In Leon, it was basically related to legally and lawfully obtained warrants that were later found to be defective. Um, if the proper channels were initially gone through, officers were able to rely on that warrant and then proceed with the search, and any evidence obtained from that warrant would be allowed in court. The other issue with the exclusionary rule is that it's not very effective as a deterrent. There's been a few studies in this one I read done by Stewart. He noted that in the late 1970s that 6% of the cases were thrown out for Fourth Amendment issues, and this is thrown out in court. So the case has already gotten past the filing attorney, has already been screened, and 6% of the cases were just outright thrown out for search and seizure issues. What they also found is that before the case even got to court, 30% of all narcotics cases were getting kiboshed and thrown out by the filing DAs for search and seizure violations. So I mean, 30% of drug cases, that's a third of all drug arrests were getting thrown out because there was issues with the searches that were being done. That's a very high number. And here we have a just kind of a chart that depicts some of the information from that Stewart study. Just noting that of all the cases that were taken to filing district attorneys, you look at Pomona there, 11% or almost 12% of all rejected cases were rejected for search and seizure issues. Cases get rejected all the time, whether it's lack of evidence, whether the victim becomes non-desirous, whether it's a he said she said, and the filer doesn't believe that they're going to be able to prove it. But for 12% of those cases to be just thrown out because there's search and seizure issues shows that the Fourth Amendment is just being violated way too much. So what I tried to come up with was a better way to do it. How can we cut down on all these Fourth Amendment violations if the exclusionary rule's sole purpose is to deter police misconduct, and it's obviously not doing it with those numbers that Stewart just brought up? How can we make it more effective? And so, some of the things that I came up with was actual punishment to the officers involved. Whether that be, if you go to court and you have a case that's thrown out for search and seizure issues, your department needs to know about that. So that they can investigate further, so they can at the very least keep a running tab of how many violations you're doing, and there needs to be some kind of repercussion to that, or some kind of directed training so that you don't continue to violate the Fourth Amendment over and over again. And it may, if it's a department-wide issue, then at least we'll know that there needs to be department-wide training, or better, more directed training, more specific training to ways the law is being violated. Now, if there's outright criminal or negligent activity, that needs to be found out as well, and if that's occurring, needs to be taken care of severely. There's no room for uh, intentional violations of the Fourth Amendment. That's just not what police departments should stand for. So, in addition to training, being adaptive and improving, um, there also needs to be escalating punishment for repeated violations, and that's kind of common sense there. But what I did want to make sure is that the good faith exception remains in place, because we don't want to uh, set obviously guilty people free based on minor technical violations or procedural errors. We still want to make sure that bad guys are going to jail. Um, that's basically all that I have for you. I appreciate you listening to my presentation on the Fourth Amendment and the exclusionary rule. And from Southern California, have a good night.